Hello to you all. I am Tanya Pandey and I welcome you to this episode of Courts This Week on Live Law. I hope you've been taking good care of yourself and working on boosting your immunity. We are here to find out the latest court updates, so let's dive right into it, beginning with the Supreme Court. The Supreme Court has permitted the private unaided schools in Rajasthan to collect annual school fees from their students as fixed under the Rajasthan Schools Regulation of Fee Act 2016 for the academic year 2019 to 20. The bench of Justices A.M. Khanwilkar and Dinesh Maheshwari, however, directed the schools to provide deduction of 15% on that amount in lieu of unutilized facilities by the students during the relevant period of academic year 2020 to 21. Before the Apex Court, school management had contended that none of the provisions of the Disaster Management Act 2005 or the Rajasthan Epidemic Diseases Act 2020 or Rajasthan Schools Regulation of Fee Act authorizes the state government to reduce the quantum of fees to be collected by the private schools. The top court held that the statutory authorities under the Disaster Management Act of 2005 have no power to deal with the subject of school fee structure of private unaided schools. However, the court upheld the constitutional validity of the Rajasthan Schools Regulation of Fee Act 2016 while reading down sections 4, 7 and 10 of the Act. Referring to the Constitution Bench judgments in TMA Pai Foundation case and the PA Inamdar case, the court observed that government has power to provide for external regulatory mechanism for determination of school fees, or so to say, fixation of just and permissible school fees at the initial stage itself. A Constitution bench of the Supreme Court has struck down the Maratha quota in excess of 50% ceiling limit, holding it to be unconstitutional. The court unanimously held that there were no exceptional circumstances justifying the grant of reservation to Marathas in excess of 50% ceiling limit as a socially and economically backward class. The bench struck down the Maharashtra SEBC Act 2018 to the extent it held Marathas as a socially and economically backward class as violating the principles of equality, as also the reservation given to Marathas in job and education. However, the bench clarified that the judgment will not affect the PG medical admissions under Maratha quota made till 9 September 2020. A 5-judge bench comprising of Justices Ashok Bhushan, L. Nageshwar Rao, S. Abdul Nazir, Hemant Gupta and S. Ravindra Bhatt pronounced the judgment in a batch of pleas challenging the Maharashtra SEBC Act 2018, which provides 16% reservation for Marathas in job and education. After the grant of Maratha quota, the reservation in Maharashtra became 68%. The court, by 3:2 majority, held that the 102nd Constitutional Amendment has abrogated the power of states to identify socially and educationally backward classes, and that after introduction of Articles 338B and 342A of the Constitution, the final say in regard to inclusion or exclusion is firstly with the President and thereafter with the Parliament. Justice S. Ravindra Bhatt, in his separate but concurrent judgment on this point, observed that to dilute the 50% benchmark further would be to effectively destroy the guarantee of equality, especially the right not to be discriminated against on the grounds of caste. The bench refused to revisit the Indira Sahani versus Union of India judgment and held that the majority opinion in Indira Sahani is that normally reservation should not exceed 50% and it is only in extraordinary circumstances it can exceed 50%. In a significant judgment, the Supreme Court on 6th May upheld the freedom of media to report the oral observations and discussions made by judges and lawyers during a court proceeding. A bench of Justices D.Y. Chandrachud and M.R. Shah held that freedom of speech and expression under Article 19(1)A of the Constitution extends to reporting judicial proceedings as well. The bench was delivering its judgment in a petition filed by the Election Commission of India seeking to restrain media from reporting oral remarks made by judges after the Madras High Court orally said that the ECI should probably be booked for murder for being singularly responsible for COVID-19 second wave by allowing election rallies. Real-time reporting of courtroom proceedings in social media is not a cause of apprehension, but a virtual extension of the concept of open court, the court observed. The bench also observed that the internet and social media have refashioned and, in significant ways, revolutionized the means through which information is relayed. Unless live streaming and archival of court proceedings sees the light of the day, the absence of records of oral proceedings would continue to bedevil the system, the bench remarked. The court also noted that 3 years have elapsed since the decision in Swapnil Tripathi versus Supreme Court of India, which highlighted the importance of live streaming of judicial proceedings. The Supreme Court on 4th May struck down the West Bengal Housing Industry Regulation Act 2017, holding it to be unconstitutional in view of the 2017 Real Estate Regulation and Development Act, RERA, which is the central legislation on the identical subject matter. However, with a view to prevent any chaos in the real estate industry in the state, the court, in exercise of its power under Article 142, clarified that all sanctions and registrations previously granted under the HERA prior to the date of this judgment shall continue to prevail. The bench of Justices Chandrachud and M.R. Shah was pronouncing the judgment on a plea filed by the Forum for People's Collective Efforts, an umbrella home buyers association, challenging the constitutional validity of the Act, which is more or less identical to the centre's RERA. In a judgment delivered on 3rd May, the Supreme Court has reiterated the principles of interpretation of a contract. In seeking to construe a clause in a contract, there is no scope for adopting either a liberal or a narrow approach, whatever that may mean. The exercise which has to be undertaken is to determine what the words used mean, the bench of Justices L. Nageshwar Rao and Vineet Saran observed. The court made this observation while dismissing an appeal against a judgment of the Appellate Tribunal of Electricity at Delhi, by which the order passed by the Karnataka Electricity Regulatory Commission, KERC, was reversed. KERC had dismissed the petitions filed against the reduction of the tariff payable by Bangalore Electricity Supply Company Limited, that is the BESCOM, from Rs 6.10 per kilowatt hour to Rs 4.36 per kilowatt hour, and imposition of damages of Rs 20 lakh for delay in commissioning the plant. Taking note of the surge of the second wave of COVID-19 pandemic, the Supreme Court has passed a slew of directions to decongest prisons. I'd like to point out a few here. There is a direction that authorities should not make arrests in violation of the guidelines laid down in the 2014 judgment in the case of Arnesh Kumar versus State of Bihar, which had held that arrests should be an exception in cases where the offences are punishable with less than 7 years imprisonment. Another direction is that the high-powered committees constituted last year shall consider release of prisoners at the earliest, and that all those inmates who were granted parole pursuant to the Supreme Court's earlier orders should again be granted parole for a period of 90 days in order to tide over the pandemic. The Supreme Court has held that the Proviso 6 to Section 92 of the Evidence Act will not apply if a document is straightforward and without any ambiguity in meaning. Section 92 of the Evidence Act bars giving oral evidence with respect to the contents of a written document. However, Proviso 6 to Section 92 allows the admission of facts external to the document, which shows in what manner the language of a document is related to existing facts. The Supreme Court was considering an appeal in which the question was whether the agreement in the case should be interpreted as a license to run a business or a license to occupy the rented premises in which the business was located. The Bombay High Court had held the agreement to be a leave and license agreement to occupy the rented premises by relying on Proviso 6 and also Section 95 of the Evidence Act. And so the High Court had held the civil suit to be not maintainable. In appeal against the High Court judgment, the Supreme Court held that it was clear from the reading of the contract that the parties had intended to transfer business from the appellant to the respondent, and was not meant as a lease or license for the respondent to conduct business. The Supreme Court also held that reliance on Proviso 6 to Section 92 and Section 95 was not called for in the case, as the document was clear in its meaning. Let us now go over the important High Court updates. The Karnataka High Court has held that non-compliance of Section 35 of the Protection of Children from Sexual Offences Act, that is the POCSO Act, will not entitle the accused to be released on default bail. Section 35 of the POCSO Act provides that the evidence of the child shall be recorded within a period of 30 days of the special court taking cognizance of the offence, and reasons for delay, if any, shall be recorded by the special court. Further, Section 35 also lays down that the special court shall complete the trial as far as possible within a period of 1 year from the date of taking cognizance of the offence. A division bench of Justice B.V. Nagarathan and Justice M.G. Uma added that Section 35 is not to be interpreted in favour of the accused so as to mandate release of the accused if for any reason evidence is not recorded within a period of 30 days of taking cognizance of the offence, or the special court not completing the trial within a period of 1 year from the date of taking cognizance of the offence. Dealing with a plea wherein the petitioner alleged that he was under an apprehension that the Delhi government was misusing public money, the Delhi High Court dismissed the plea with Rs 50,000 cost. The bench of Chief Justice D.N. Patel and Justice Jasmeet Singh noted that reliance had been placed by the petitioner for filing the writ petition on a tweet by somebody else on Twitter. When the court raised a query as to whether the petitioner had even gathered information under the Right to Information Act, the answer given by the counsel for the petitioner was that he had never applied for the same. Therefore, finding no reason to entertain the writ petition, the same was accordingly dismissed with costs. Reviving the suo motu writ petition instituted last year, the Guwahati High Court has sought details from jail authorities with regard to the children lodged inside jails in Assam in view of rising COVID-19 cases in the state. The development came from a division bench comprising of Chief Justice Sudhanshu Dhulia and Justice Manash Rajan Pathak, who had sought state government's response on the number of inmates inside Assam jails who have been infected from COVID-19, and also about the measures undertaken by the jail authorities for dealing with the issue. Dealing with a public interest petition raising the issue regarding violence which took place in the state after the Assembly elections 2021, the Calcutta High Court on May 7th sought details regarding the latest status of the law and order situation in the state. Significantly, considering the importance where life and liberty of the people in the state of West Bengal is at stake, and the issues sought to be raised by the petitioner, a larger bench was constituted to hear the petition. Those were the top developments from last week. Thank you for joining us. I am Tanya Pandey and I wish you a lovely week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.